Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. In an earlier video, we did a quick overview of Donald Trump's executive order limiting birthright citizenship. In this video, we're going to take a closer look at that executive order. In short, we think Trump's efforts to limit birthright citizenship are unconstitutional and will not be upheld by courts. We know that this won't prevent fear and anxiety being caused by the order, but we hope this video will help to dispel some of that fear and uncertainty. First, let's talk about what Trump's executive order on birthright citizenship tries to do. The order, which is called the Executive Order Protecting the Meaning and Value of American Citizenship, says that children born in the United States on or after February 20th, 2025 will receive U.S. citizenship only if their mother or father is a permanent resident or citizen of the United States. The order says that children born in the U.S. on or after February 20th will not receive U.S. citizenship if their parents are either undocumented or in the U.S. legally on a temporary visa, which includes a visitor or a tourist visa, a student visa, or a temporary work visa, like an H-1B, an L-1, or an O-1, for example. The executive order ordered government agencies not to issue passports, social security cards, or other documents to these children starting on February 20th. The order also defines mother and father as the biological mother and father, which could exclude from U.S. citizenship those born in the U.S. to same-sex couples or through artificial reproductive technologies. The first thing that's important to understand is what an executive order is. An executive order is simply a directive from the president to the executive branch, which includes the U.S. Department of Homeland Security, the Department of State, and other agencies. It is not a law passed by Congress. When an executive order conflicts with a law that's passed by Congress, the law wins. And when an executive order is in conflict with the U.S. Constitution, the U.S. Constitution wins. Why is that relevant? Because Trump's executive order is clearly in conflict with the 14th Amendment of the U.S. Constitution. The 14th Amendment says, all persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. There's also a federal law that has the same language as the 14th Amendment at 8 U.S.C. section 1401. That language seems pretty clear. Someone is born a U.S. citizen if they're born in the United States and subject to the jurisdiction of the United States. Subject to the jurisdiction of the United States means that the person can be punished for not following the law. If a person can be arrested, fined, imprisoned, or detained for violating a law of the United States, they are subject to the jurisdiction of the United States. Those who are here on temporary visas or who are undocumented can definitely be charged, arrested, imprisoned, or detained. Many of Trump's executive orders depend on this. So they are clearly subject to the jurisdiction of the United States. In fact, the very term illegal alien depends on such individuals being subject to U.S. law. So who isn't subject to the jurisdiction of the United States? First of all, diplomats and their immediate family members. Diplomats have diplomatic immunity in the United States, meaning that they generally cannot be arrested or prosecuted for violating the laws of the United States. They continue to be subject to the laws of their home country even while they're in the U.S. When a foreign diplomat has a child in the U.S., that child also has diplomatic immunity and therefore is not born a U.S. citizen. Beyond diplomats and their immediate family members, there are a few, if any, people in the U.S. who are not subject to U.S. jurisdiction. If the U.S. were, for example, to be occupied by soldiers of a foreign nation, those invading soldiers would not be considered subject to U.S. law since they are agents of the foreign nation. Some people have made the argument that undocumented immigrants are like invaders and, like invading soldiers, should not be considered to be subject to the jurisdiction of the United States. In fact, several of Trump's executive orders refer to the situation at the southern border as an invasion. His use of this word was not an accident. Setting aside the fact that immigration rates at the southern border have plummeted since the summer of 2024 and are currently at their lowest rates in years, far from an actual invasion, Unauthorized immigrants also don't fit the legal term of invaders for purposes of the 14th Amendment. To understand why, it's helpful to look at the history behind the 14th Amendment. The 14th Amendment was proposed in 1866, just after the U.S. Civil War. Before the 14th Amendment was passed, the law in the United States was based on an 1856 Supreme Court case called Dred Scott v. Sanford. In that case, the Supreme Court held that former slaves cannot become U.S. citizens, even after they're freed. The 14th Amendment directly addressed this, saying that anyone born in the U.S. and subject to its jurisdiction is born a U.S. citizen. But did the people who proposed and adopted the 14th Amendment have immigrants in mind? Again, the language of the 14th Amendment is very broad and applies to anyone born in the U.S. In addition, there is clear evidence that the intent of those who proposed and adopted the 14th Amendment wanted it to be broadly applied to everyone born in the U.S. and subject to its jurisdiction, including those who entered the U.S. without authorization. Two things make this very clear. First, the Senate debates regarding the 14th Amendment make it clear that those who proposed and adopted the 14th Amendment understood that it applied to immigrants. Fifth Circuit Judge James Ho researched this and has written about it. In his piece titled Defining American, he writes that proponents and opponents of birthright citizenship alike consistently interpreted the 1866 Civil Rights Act just as they did the 14th Amendment to cover the children of aliens. Ho adds that in one exchange, Senator Edward Cowan, a Republican from Pennsylvania who opposed birthright citizenship, asked whether the act will not have the effect of naturalizing the children of Chinese and Gypsies born in this country. In response, Senator Lyman Trumbull, a Democrat from Illinois, stated, "Undoubtedly, the child of an Asiatic is just as much a citizen as the child of a European." Later, Senator John Conness, a Republican from California, responded to Senator Cowan's concerns by stating, "The proposition before us relates simply in that respect to the children begotten of Chinese parents in California, and it is proposed to declare that they shall be citizens. I am in favor of doing so. We are entirely ready to accept the provision proposed in this constitutional amendment that the children born here of Mongolian parents shall be declared by the Constitution of the United States to be entitled to civil rights and to equal protection before the law with others." As Judge Ho concludes, text and history confirm that the citizenship clause reaches all persons who are subject to U.S. jurisdiction and laws, regardless of race and alienage. Second, it was well known at the time that the 14th Amendment was adopted that some slaves had been illegally smuggled into the U.S. and were in the U.S. without authorization. Yet the 14th Amendment clearly applied to them. Constitutional scholar Akhil Amar has spoken about this, and it is a fascinating piece of history behind the 14th Amendment. In 1807, Congress passed an act prohibiting the importation of slaves, which prohibited the importation of slaves from outside the U.S. starting in 1808. However, slaves continued to be illegally smuggled into the U.S. for years. This was well known at the time. In fact, President Lincoln refused to issue a pardon to Nathaniel Gordon, who was convicted of trading in slaves and was executed for his crimes in 1862. In making his decision not to issue a pardon, President Lincoln wrote, "I think I would personally prefer to let this man live in confinement and let him meditate on his deeds. Yet in the name of justice and the majesty of law, there ought to be one case, at least one specific instance, of a professional slave trader, a northern white man, given the exact penalty of death because of the incalculable number of deaths he and his kind inflicted upon black men amid the horror of the sea voyage from Africa." In other words, at the time the 14th Amendment was proposed in 1866, it was well known that slaves continued to be illegally smuggled into the U.S., meaning that when the 14th Amendment was adopted and ensured that former slaves were guaranteed U.S. citizenship, this certainly included those who were in the U.S. illegally. In this video, we've looked at the text of the 14th Amendment and the history behind it. Let's close by looking at the legal precedent following it and how courts have interpreted and applied it. What is clear is that again and again, courts have held that birthright citizenship is guaranteed by the 14th Amendment to those born in the U.S. and subject to its jurisdiction, regardless of their immigration status. The key case on this question is Wong Kim Ark, a case decided by the Supreme Court in 1898. In Wong Kim Ark, the question before the court was whether Wong Kim Ark, who was born in San Francisco to parents who were nationals of China but were not diplomats, was a U.S. citizen. The Supreme Court's holding was significant, so we'll take the time to read a longer part of it. In Wong Kim Ark, the Supreme Court concluded as follows: "The foregoing considerations and authorities irresistibly lead us to these conclusions. The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens, with the exceptions or qualifications as old as the rule itself of children of foreign sovereigns or their ministers, or born on foreign public ships, or of enemies within and during a hostile occupation of part of our territory, and with the single additional exception of children of members of the Indian tribes owing direct allegiance to their several tribes. The amendment, in clear words and in manifest intent, includes the children born within the territory of the United States of all other persons of whatever race or color domiciled within the United States. Every citizen or subject of another country while domiciled here is within the allegiance and the protection and consequently subject to the jurisdiction of the United States. To hold that the 14th Amendment of the Constitution excludes from citizenship the children born in the United States of citizens or subjects of other countries would be to deny citizenship to thousands of persons of English, Scotch, Irish, German, or other European parentage who have always been considered and treated as citizens of the United States." In 1982, the Supreme Court again considered the question in Plyler v. Doe. In that case, the Supreme Court held that the children of unauthorized immigrants are clearly subject to the jurisdiction of the United States, stating that no plausible distinction with respect to 14th Amendment jurisdiction can be drawn between resident aliens whose entry into the United States was lawful and resident aliens whose entry was unlawful. So, what is likely to happen with Trump's executive order on birthright citizenship? We think that courts will prevent it from ever going into effect. The order has already been temporarily enjoined by a district court in Seattle, Washington. Hopefully after watching this video, you won't be surprised to learn that the judge in that case, who was appointed by President Ronald Reagan, said that Trump's executive order was blatantly unconstitutional. In spite of this, Trump's order will still cause confusion and fear. We hope this video has helped provide a little bit of clarity and given some peace of mind. At the end of the day, fortunately, even the President of the United States does not have the power to change the Constitution on his own, and that includes the fact that the 14th Amendment gives citizenship to all those born in the United States and subject to U.S. jurisdiction. If you have any questions, feel free to put them in the comments. Stay tuned for future videos. We look forward to seeing you soon.